Prince Harry just lost huge in court. He's suing these tabloids, and not only did the judge just pretty much admit that Prince Harry is indeed lying, he's now being forced to pay them nearly £50,000. Welcome to Popcorn Planet. I am Andy Signor. This one's wild. This one just broke past hour or so, and yes, Prince Harry is now ordered to pay the Mail on Sunday nearly £50,000 after losing an attempt to strike out part of the paper's defense in the libel case. Now, this was a hearing. He requested a separate sort of part of it, an attempt to throw it out, saying that this is nonsense. We have the sort of full breakdown summary here, but just to give you sort of the overall, he's fighting this newspaper, because the Associated Newspapers, over an article written about his fight with the Home Office, which is basically British government, concerning his security arrangements had he tried to have the company's honest opinion defense thrown out. So here's where I'm going to go to the defense. In fact, I think this is the best thing for us to go through because it's going to lay it all out as cleanly as possible. Here was the article in question, just for those of you who are out of the loop. Article given the rise is revealed how Harry tried to keep his legal fight over bodyguard's secret. Then minutes after Mail on Sunday broke story, his press release machine, PR machine, tried to put positive spin on the dispute. So that's the headline in question that Harry's deeming defamatory, unfair, unjust, etc. This was published in the Mail on Sunday on February 20th, 2022, concerned a claim for judicial review that the claimant had launched that challenged the government's decision not to continue providing the Duke of Sussex with publicly funded security when he was in the UK. So here's what the court had earlier deemed that, so the earlier decision on the meaningful article, the court decided that the meaning of the article was his legal claim against the Home Office over the provision of police protection, and the Duke of Sussex had initially sought confidentiality restrictions that were far-reaching and unjustifiably wide, and were rightfully challenged by the Home Office on the grounds of transparency and open justice. Duke of Sussex was responsible for public statements issued on his behalf, which claimed that he was willing to pay for police protection in the UK, and that his legal challenge was to the government's refusal to permit him to do so, whereas the true position, as revealed in documents filed in the legal proceedings, was that he had only made the offer to pay after the proceedings had commenced. So he's saying, I offered to pay, guys. I wasn't trying to have the taxpayers do it, but that only happened after this all went down. The Duke was responsible for attempting to mislead and confuse the public as to the true position, which was ironic given that he now held a public role in tackling misinformation. So this is the rulings that are coming in from the court, mind you, which is important for you to keep in mind as we read this. Court also held that the underlying works were expression of opinion. Following that judgment, the Duke of Sussex reformulated his claim for libel to raise a complaint only about meanings B and C, these two things. Now, the newspaper defended this, saying in answer to the Duke of Sussex's libel claim, the defendant had relied upon the statutory defense of honest opinion. The defense is available in the relevant statutory criteria. In the earlier judgment, the court had determined that the first and second conditions for this defense are met. The dispute between the parties is over the third condition, whether an honest person could have held the opinion of the basis of any fact which existed at the time the article was published. And again, that headline being, Harry tried to keep his legal fight over bodyguard's secret. Then minutes after Mail of Sunday broke story, his PR machine tried to post positive spin on the dispute. That's what is in debate here. In summary, the argument, the defendant, Harry, argues that the facts in meaning B are substantially correct and based upon the Mail of Sunday's defendant are substantially correct based upon an honest person could have expressed opinion. Dismissal application, the Duke brought an application to strike out based on this defensive honest opinion. The court has the power to grant summary judgment against the defendant, the effect of which is to dismiss a defense to a claim without the need for evidence to be considered. Before it will grant summary judgment, the court must be satisfied that the defense has no real prospect of success. Basically, the judge needs to be positive that Mail on Sunday can't win this. It's impossible. That's when they could say, all right, Harry, you're right. We throw this away. In other words, that is fanciful to think that the defense could succeed at trial. That's what they have to believe. The Duke of Sussex argued that a key factor relied upon the defendant to support his defense, that he'd only made the offer to pay for his security after the proceedings had commenced, was wrong. He had made an offer to pay at the meeting in Sandringham in January, the Sandringham offer. Because of that, the Duke of Sussex argued the defendant would not succeed in demonstrating the third condition for the defense of opinion. So he did this with his family, apparently. This was a while back. He made that offer to the family and Sandringham, not to the government specifically. And that's the problem. He's claiming, well, I said it. I told my family back then. But now the government's like, well, you never told us. So therefore, how would the public know? How would anyone else know that you were trying to pay for it when you didn't announce it until after the proceedings went public? The defendant argued that the Sandringham offer was not an offer made to the government. This is the paper arguing. The first time the Duke had made an offer to pay to the government was only after he commenced his claim for judicial review. Defendant also relied upon the issuing of 2 public statements on behalf of the Duke of Sussex concerning his claim for judicial review against the government, which the defendant says was misleading. The press statement and the background briefing were misleading to the public, and the court decided that, yes, they were. They refused his dismissal application. The court concluded that the defendant's defense of honest opinion has real prospect of success, not just merit or could, real prospect of success, and should go forward to trial. Defendant has a real prospect of trial at demonstrating that the Duke of Sussex had not made an offer to the government to pay for his security before he began his proceedings for judicial review. At trial, the court may find that Sandringham offer is irrelevant to the defense of honest opinion. The honest opinion defense does not rely upon just one fact. The defendant has a real prospect. The tabloid has a real prospect at trial at demonstrating at least the following facts: that the press statement suggested that prior to the judicial review claim, the Duke of Sussex had made at least one previous offer to the government to pay for his state security, which offers had been rejected by the government. Or that the background briefing suggested that the judicial review claim was a challenge to the government's refusal to accept an offer to pay for his state, and that these suggestions were not accurate, or at least did not give the full story. But they're not going to be able to do that. So it's just the court held that it's not fanciful that the defendant will be successful at trial and demonstration, determining that the public statements issued over the Duke's behalf sought to promote the JR claim as his battle against the government's pervasive decision to refuse to allow him to pay for his own security. There is real prospect that the defendant will succeed in demonstrating that this was a misleading description of the issues in the justice claim review, arguably promoted because it was hoped to show the Duke's claim in positive light, whereas a portrayal of the justice review claim as the Duke trying to force the government to reinstate his taxpayer-funded state security risked his appearing in a negative light. I anticipate that at trial, the defendant may well submit that this was a masterclass in the art of spinning, and that the defendant argues it was successful in misleading and or confusing the public. The resulting media coverage relied upon the defendant did indeed characterize the judicial review claim as the Duke's challenge to the government's refusal to his offer to pay. So basically, if the defendant does not establish these facts at trial as a real prospect of demonstrating the third element for an honest opinion defense, that an honest person could hold the opinion that the Duke of Sussex was responsible for attempting to mislead and confuse the public as the true position of his judicial review claim. And that was ironic given that he held a public role in tackling misinformation. So now this will go to trial unless it's settled before then at some point in early next year. Unless they reach an agreement, there will be a further hearing on December 12th. That is the hearing now, in which the court will consider the orders that should be made, meaning, which is this, that he now must pay nearly £50,000 to the Mail on Sunday because he lost this hearing. And this was an unnecessary sort of push that cost money that he's now having to pay. Now, obviously, that could all change as a settlement or a later hearing happens, but this is a huge loss for him. Huge loss, because not only is he now paying the tabloids that he's suing, which is never obviously a win, it's exposing this more. He's so clueless. He's out there saying he didn't do this, but he did. And maybe his PR machine did, and he had no idea, but come on. Nonsense. Your PR machine is responsible for you. This is now multiple instances where Harry and his PR machine are out there doing secret things, which they allege the royals have done to them, but they practice it almost more, it seems. They keep digging their own graves. And so now, how is this? Harry did try to keep his legal fight secret. He wanted it all confidential. And then as it broke, he tried to put this positive spin saying that he tried to pay for it when the government's like, he never tried to pay for it. They never came after us to pay for it. So this is a completely legit opinion piece, article revealing what happened, and he's going to lose it. It sounds like even the judge is like, this is done deal. What are you doing? So Harry, man, this photo is fitting for you because you are just bumbling left and right. All these lawsuits, you could lose them all. This could be millions of dollars at stake. and none of them seem worthy. None of them seem like he has a shot in hell at winning. I'm just floored. So there it is. First up, his first big loss of potentially many here. What do you guys think of this? Are you surprised that he was trying to keep this all private? And then once the people found, his PR machine did seem to put out a bunch of positive spin saying he did try to pay, which the government said, well, no, you didn't. Are you surprised by this? I want to hear your thoughts down below. Also, if you haven't already, hit that subscribe button, hit that bell for alerts, smash that thumbs up, and leave your comments on your thoughts on this. Are you surprised? Let me know, and stay tuned for more coverage of royal madness and pop culture stuff here on Popcorn Planet.